From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Bryan Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Hello, everybody, and welcome to today's episode of FLALAW on the radio. I am your host, Matthew Noyes, and I'm thrilled to be with you again today as we navigate the legal issues that matter to you and your family. For the past month, we've had Jacqueline Bryant, my law partner, be the host. And so this month, it will be me and many of my guests. Today, I'm joined with my esteemed co-host and law partner, Bryan Caulfield. We are both from Bryan Caulfield, Averill, and Noyes, a personal injury law firm that proudly sponsors and presents FLALAW on the radio. Bryan brings a wealth of knowledge and experience to our discussion, and I'm excited to dive right into today's topics with him. Now, as always, we always want to hear from you on FLALAW on the radio, so if you have questions or thoughts regarding today's topics, there are 3 ways that you can join in the discussion. 1, you can call us live and be on the air with us. That's 727-441-3000. Or we are presently live on our firm Facebook page at Bryan Caulfield, Averill, and Noyes Injury Lawyers. Pernick is spelled P-E-R-E-N-I-C-H. And you can just type in your comment right there, and I can see your comment, and Bryan and I can address your comments. And the third way is the YouTube channel. We are live on our YouTube channel as well. And that is also Bryan Caulfield, Averill, and Noyes. Again, Pernick, P-E-R-E-N-I-C-H. Any ways you can get in touch with us today, that would be wonderful to join in the discussion. And if you can't reach us today, you can always jump onto Spotify or follow us on any of the podcast platforms so you don't have to miss one episode whatsoever. But today we're going to discuss some significant developments in Florida legislature, particularly Governor DeSantis' recent vetoes concerning e-bikes and sovereign immunity caps. I always like e-bikes because Ed's on the other side of the glass, and I always want him to join in on that discussion as well. We're also going to talk about critical issues surrounding uninsured motorist coverage and shedding light on what families should be aware of. So stay tuned, grab a seat, and let's unpack those important topics together. Bryan, are you ready to rock and roll with me?
I'm ready, Matt.
Let's
Bring
do
it
it.
on.
Let's
Bring
do
on
it.
the questions live.
That's right. Bryan, I know you've been on the show before, but it may be in a little while. So why don't you reintroduce yourself to the new listeners? Tell them a little bit about yourself, the road to becoming an attorney, your legal career, and why you chose personal injury to be your area of specialty.
All right, Matt, thanks a lot. And yes, I am an attorney. I'm actually entering year number 38 as a personal injury lawyer here in Pinellas and Hillsborough County area primarily, but we also do cases statewide. I'm a board-certified civil trial lawyer. I handle all kinds of personal injury cases, whether they be auto accidents, motorcycle accidents, bicycle or e-bike accidents, boat or wave runner accidents, even airplane accidents. So any type of personal injury or wrongful death claim that arises in the state of Florida, I've been handling that type of case for almost 4 decades now.
Yeah, why'd you choose personal injury instead of corporate law or probate or anything like that?
Well, you know, when I was in law school, I did take a clerking job and did work on some other areas of law. And I just didn't really like, representing corporations and that was kind of impersonal. I just liked it a lot better dealing with actual people. And I've always kind of had a soft spot for the underdog, so to speak. And so I kind of enjoy taking on bigger corporate interests, kind of big money defendants that have
David versus Goliath type of.
It really is that in a sense.
Yeah, and so you and I are part of Bryan Caulfield, Averill, and Noyes. We are one of the longest established personal injury law firms in Tampa Bay. Can you tell our listeners, reintroduce the firm to our listeners?
Sure. Our firm has been around since 1955. You really don't see that much of that. Obviously, there are a lot of personal injury law firms. All you have to do is turn on the TV or
stay home
keep
one
listening
afternoon
on the radio. And as you know, there are plenty of firms, but there aren't many firms that have been around as long as we have. Our senior partner at the time, Guy Pernick, and his partner then, were really the first people to try to kind of specialize, and they pretty much went around Clearwater and told the other lawyers, hey, we're going to start specializing in just personal injury type claims. So you might say they were personal injury lawyers before being a personal injury lawyer was cool.
That's right.
So we have a long history of representing folks in our community.
And I think they started off in the old fire station. Is that right, on Cleveland?
There's some interesting pictures of kind of the first office.
Yeah. And I know our longevity makes us different from the TV personal injury lawyers. What else makes Bryan Caulfield, Illinois different from, those guys you may see on the TV commercials?
Well, I think, with our firm, we've always done things a little bit differently, whereas, for example, you might not even meet your lawyer. If you go sign up for someone on a personal injury case at some of those bigger advertising law firms, they might send a non-attorney out to your house to get you to sign paperwork and really be unable to answer the questions that you have initially. But, we've always tried to stay old school, and, unless the client doesn't want it, we always meet with the client initially at the initial part of the case so that we can start to form a relationship with those people that's based on trust, that's based on kind of them getting to know you personally as well. And I think that helps us do a better job of understanding, what the injuries are doing to them.
I agree 100%. And I had one client tell me that they were a part of one of those other law firms, and they came over to me because every time they called, they got an AI-generated call. And so they would think they're talking to a human, but then they realize that it was just really an AI person taking down the information and filling in the responses. And so they really lack that one-on-one relationship. And so they're always happy when they get to talk to our legal assistants or us attorneys as well. So I think that really makes us different from them as well.
Agreed.
Now, you're board certified. Can you let our listeners know what that means and how many attorneys reach that status?
Yeah, being a board certified lawyer is different than just passing the Florida bar. Every lawyer that you see had to pass the bar exam, but there are some lawyers that have gone on and are able to kind of be tested by more rigorous standards. To be a board certified civil trial lawyer, you have to have at least 15 jury trials. You have to be basically blind survey where the Florida bar finds out from you who your opponents were on those cases and who the judges were. And they'll contact one of the judges and they'll contact all of your opponents over a period of time until you got 15 jury trials. They'll contact every single one of them, and they will find out without disclosing to you what those lawyers think of your competence and ability. And if you pass that part of the test, then you're allowed to actually sit for a board certification exam. And so I've been a board certified civil trial lawyer since 1993, and I have to recertify every 5 years to demonstrate continued competency in the area of being a trial lawyer, both by having more continuing legal education credit hours than a base attorney would have, and also having the minimum number of trials during that recertification period to keep your board certification.
And about what percentage of lawyers are board certified?
Last time I checked, it was about 1.86%,
Of all the lawyers.
2% of all the Florida lawyers are actually board certified civil trial lawyers.
And we have two in our office,
We do
don't we?
indeed.
It's you and Lori Robinson. So two out of that few already is a wonderful testament of our dedication to helping people. Now, I am going to just make a little note, and maybe Ed can help me out. I got a little message on Facebook saying that there is a humming sound in the background for Facebook. I don't know if it's something I did on these controllers or not, but it seems to be a humming sound. But that's to...
I hear that in my headphones as well.
I do too, actually. So, but why don't we do this? Why don't we jump right into the areas that we want to talk about? And one of the most surprising things that I wanted to talk about is Governor DeSantis. He gets the budget, he gets the bills, and he has a line item veto. He can veto things that he doesn't want to be passed as law or as a budget item. And one of the things that was passed unanimously, both Democrats and Republicans in both houses passed the e-bike bill. It was Senate Bill 382, and that was aimed to curb growing e-bike safety concerns. The bill talked about speed limits, that it would require riders to slow down to 10 miles an hour when approaching a pedestrian. Talked about accident reports. Unfortunately, many of the accident reports when it involves an e-bike doesn't say it's an e-bike. It may just say it's a bicycle. It may say it's an e-bike. It may not say anything at all. And so that bill helped enforce that rule to say that it is still an e-bike or a motorized scooter. There was a task force that was supposed to be established to look into the issues, and there was a fine that could be $100. But although all the legislature said, hey, this is a good idea, let's do it, Governor DeSantis vetoed it. First of all, Brian, what are your thoughts about that bill? And in our experience as personal injury attorneys, what's your experience of having to represent people involved in e-bike accidents and scooter accidents and such?
Well, it's interesting that you pointed out that it was actually a bipartisan bill. With bipartisan is a word that doesn't exist really any longer. And for the most part, unfortunately, in politics, things are usually passed along party lines. But bipartisan meaning both the Democrats and the Republicans in the Florida House were in favor of this e-bike regulation bill, because really what it was an effort to keep up with the times. Years and years ago, you never heard of an e-bike. You heard of a moped.
Right.
They weren't terribly popular, but they became more popular. But e-bikes have exploded. And as you've kind of pointed out, you've used kind of the word e-bike or e-scooter,
scooter,
or motorized or electric motorcycles. There are so many different types of words for these things, but the bottom line is they're new.
Right.
And the Florida legislature was attempting to put in some common sense reform that would, basically help with safety. They wanted speed limits. They wanted, as you said, accident reports, so that the state of Florida could gather valuable data as to just how often they're involved in either injury-type accidents or fatalities, because that's one of the purposes of accident reports, is to gather data. That's how they figure out, for example, if there's a particular intersection that might be dangerous, that might need to be redesigned, is taking in this data. So the other thing they wanted to do was do a state task force so that they could actually kind of study some of the issues that are created by e-bikes. And, I'm sure anybody that is out there on the roadways has noticed the proliferation of these bikes.
Right.
And these things are fast. In fact, some of them are lightning fast.
Right.
I know, for example, I was coming up to the intersection there at McMullen Booth Road there in Old Coachman, and I was amazed. There was a young man that when you're pulling up to an intersection and you're going to be making a right, your first thing is you're probably going to be looking to your left.
Correct.
Well, fortunately, I came to a stop because this young man with the what do you call it, electric motorcycle, it looked like a motorcycle, and he was on the sidewalk coming from south to north, and he just accelerated across the intersection, and I was amazed at the pickup of this e-bike or e-motorcycle he had. And they're going to have to try to reckon with the danger that's been created.
Right.
And all you can do is just watch the news. Every few months, like I remember seeing recently a poor mom that is now an advocate for e-bike safety. Her son was killed on one of these e-bikes. And the bottom line is, a lot of times they're too powerful for these young kids to really, ride safely on. So it's like everything else, when you have a society that is kind of advancing technologically with things like cell phones and, things like, all the social media, the law has to try to keep up with what's happening in society and try to make things safe and regulate them appropriately.
Right. Yeah. And Governor DeSantis argued that he vetoed it because he was concerned with the required speed detection that would lead to over-policing and increased surveillance of Floridians.
It's shocking.
It baffles me. Now, that's just a state law. So it didn't pass in the state, but cities and municipalities can still pass their own laws. In fact, the town of Palm Beach bans children younger than 15 from riding e-bikes and outlaws them on the sidewalks.
Yeah, and there's good reason for that. People that think bikes, whether they're electrified or not, are not dangerous are wrong. I've handled a case in which just a regular bicycle ran into someone and killed them in a neighborhood.
No, I know.
And so when you see the incredible speed that some of these bikes go at, I see some of these kids driving them, and I say to myself, I wish the parents could be out here seeing how they're riding together once you get a few of them together and they start to race and everything. And it's
Ed sees that all the time too when he's out on the road too.
Yeah, when I'm on my motorcycle and I'm doing 35 and I look over and there's a kid on his e-bike doing the same speed, keeping right up with me. Yeah. I would suggest that, we regulate our roadways by horsepower. As far as scooters and going into motorcycles and stuff, what if they regulated the sales? Let's go back to the sales of and these e-bikes I believe go by wattage.
Right.
I think what it should be is anything on a certain wattage that might do more than 20 miles an hour should only be allowed sales for kids under 16, and anything over that, it's 16 and over. So you're regulating it at the start of the sales of it.
Well, in fact,
because you gotta have a way to enforce it. If you're gonna enforce it, you have to go back to how it was sold and how it's put out on the market and stuff like that.
Right. And in fact, that bill that eventually was passed was watered down. The first bill, the previous version, had that. It prevented people from modifying the e-bikes, because that's what happens a lot. They buy the slower version and they modify it. So it made that illegal, and it also barred children from riding with a motor that was 750 watts. That's what you were talking about, Ed. And I think, and in fact, the law, that's what exists in many of the states right now. And so if they could pass a law that addresses the Class 1, Class 2, Class 3 bikes when it starts at the sale, I think that'd be very helpful as well.
And I think they need to be kept off the sidewalks.
Right.
There is a bike lane, and where there's a bike lane, you can ride them. And not only the e-bikes, but the e-scooters, the two-footed scooters. I don't know how the heck they run those things. I'd be off there in like less than a block. But they're on there doing 30 miles an hour. I don't know how the heck that thing is running.
On the trail, I hear that a lot. They're and they're dangerous on the
trail.
And then I also, but you're right, on the sidewalks, they're just flying.
And they're not stopping at streets, because I told you about a month ago, I'm pulling out, I look left, I look right, I see a kid that looks like he's just starting on the next block. As I start to pull up, he's passing in front of me.
Right.
Because he's doing 35 miles an hour.
Right.
I was that close to hitting him.
I know, that is crazy. That is crazy. And Bryan, you and I represent a lot of people that get injured on these e-bikes and on these scooters. So I wanted to kind of, alert our listeners to what kind of insurance coverage is available when someone does get injured as a e-bike or scooter user, but then also what kind of coverage is available if the e-bike user causes the crash. But let's first talk about really the e-bike user who gets injured in a crash. I know we have Florida automobile insurance. Why don't we talk about that first? In Florida, would auto insurance help that person who gets involved in a crash if he wasn't at fault for it?
Yeah, I mean, at least for those purposes, right now, these kind of e-bikes are largely, but not exclusively, they're treated like bicycles.
Right.
So people can get some help from their auto insurance to pay for their medical bills typically. But that's going to change, because what's going on right now is, you can bet, as insurance companies are having to start to pay out more and more money for injuries associated with these machines, they're going to try to write them out of the insurance policy, whether that is for yourself to try to get help from your own insurance company, or whether or not you caused the accident. Your own homeowner's insurance, for example, would say, hey, we're not covering that, because that's basically a motorized vehicle. You're going to need to get special insurance. And so as we speak, they're changing the terminology of policies to try to make sure that they're not having to cover them.
Right.
And so, again, this is all going to be guided by the legislature, because the legislature really should have an interest in making sure, number one, that there is money there if people injure themselves through their own negligence, but they also should make sure that there's money there to respond for damages they cause to an innocent person. And so it'll be fascinating to watch the way the law develops, because, look, a lot of this goes on with golf carts. There's a period of time here in Florida where you're trying to figure out, okay, there's a golf cart accident. Is there any coverage under auto insurance? Is there any coverage under homeowners insurance? And like, Ed was suggesting, they started talking about how many brake horsepower it had as to whether or not it could be considered a motor vehicle and therefore covered. And so, this is the law. That's why legislatures meet every year.
Right.
Because things are changing in our society, and it's the job of the legislature, to try to protect the citizens and to try to deal with these legal questions so that there's some certainty out there. Because, frankly, some people might want to have just dedicated insurance to make sure that, they're covering these.
Right.
So
I
it's
was
interesting.
surprised to see, when I was researching for this episode, I was surprised to see that you could buy insurance for your e-bike or for your scooter.
Sure, and and that creates a learning curve for the insurance agents.
Yeah.
Because you could probably go right now and get 10 insurance agents and put the question to them, hey, I had my golf cart, or I had my e-bike, and my child was driving it and caused an accident and injured somebody. Is there coverage? And you'd probably get 10 different answers from the people that are selling you the insurance. So it's kind of fascinating to watch the birth of these things, and then how the legislature tries to deal with them coverage-wise, and it can have profound effects on people.
Yeah, but for right now, as these e-bikes are considered bicycles, if someone gets injured while riding an e-bike, what kind of coverage is available to them under an automobile policy? Under
their own auto policy, or that of their parents, who they're resident relatives of, they're going to be turning to their own auto insurance and getting $10,000 in personal injury protection benefits. That's the mandatory coverage. But as you and I know, when you start talking about bikes and you start talking about motorcycles, you start talking about, a lot of times, very, very serious orthopedic injuries and fractures. That $10,000 can be gone quickly before the person ever gets to the hospital.
Right.
They're flying Bayflight and they've got a bill that's over $10,000. Or even if they arrive by ambulance, just the scanning, CT scans alone, you have $13,000 worth of bills.
Right.
So then, of course, you'd turn to your health insurance as well. If you have health insurance, would be a second source.
But I want to stay on the personal injury protection, because if they're driving a scooter because they don't have a car and they don't reside with somebody who has a car,
then they're SOL, as they say, and I won't.
Can't they make a claim under the person who hits them, their PIP coverage?
Well, certainly they can try.
Right. I think they'd be entitled to PIP coverage under the car that hit them.
Yeah, because
if there was no PIP available.
Yeah, because
it's a
technically they're
bicycle.
considered a pedestrian. So
Right.
it's almost like you're sitting on a park bench and you don't own your own car, and someone mows you over with a car. As long as you didn't have an obligation to have PIP yourself,
Right.
then you get the PIP coverage of that other vehicle that struck you. Because the whole idea behind the PIP statute in 1973 was we're going to cover everybody. Anyone that gets involved in any type of an auto accident or auto versus bicycle, we want there to be a base amount of coverage there. But
Right.
they weren't thinking about
e-bikes and
these
all that
things.
back in
And-
'73. That's for sure. But there is personal injury protection coverage available if you get hurt on an e-bike, and there's possibly uninsured motorists or underinsured motorists, right?
Yep, and
How does that come to play? How does come into play for an e-bike accident?
well, basically you would look at what the coverage is for the person that hit you, and if it was their fault, and let's say, for example, they ended up breaking your leg and you had to have screws and rods put into your leg and the medical bills were in the hundreds of thousands and they only had $10,000 in coverage. Well, how are you going to pay for that? Well,
Right.
one of the things you're going to do is you're going to look to see if you or your parents bought uninsured motorist coverage, which means the same as underinsured motorist coverage, and it would step in and protect you in just this type of case when the other driver is, number one, either uninsured, or number two, and what we see more of, the other driver is underinsured, meaning they don't have enough on their policy to fully pay for the damages they caused. So for the example we're talking about, if the person at fault has $10,000 and they've caused you to incur $150,000 in medical bills, you've got a case that's even more valuable than the $150,000 in medical bills. You would have to take the $10,000 from the at fault, or it'd be an option. Take the $10,000 that the other at-fault driver has. You turn back to your own company and say, for example, they have $500,000 in additional underinsured motorist coverage. You would get the balance of what your case is worth up to that full $500,000 from your own company. So that's why we consider uninsured motorist, as we call it in our industry, which means underinsured and uninsured, same thing. I consider it to be the most important coverage you can have, and I bet you and I could probably count 1,000 times the time that clients have come in after an accident and told us they have full coverage for either themselves or their child, and then when we get their policy, we find out they have no uninsured motorist coverage. You don't have full coverage if you don't have uninsured motorist coverage.
100%. And I think when we first started FLA Law on the radio several years ago, I said, I am going to make it a point to talk about uninsured motorists every single week. And so I'm glad you brought that up, because uninsured motorist coverage is the most important coverage that is available to you and your family.
Well, I sometimes I'll have clients come in and I'll ask them about their coverage, and they'll be like, what are you asking about my coverage for? I didn't cause this accident.
Right.
I don't want to make a claim on my own. And they don't appreciate that the coverage they bought themselves might be the only coverage in the case.
Right.
So you don't go out and buy insurance and assume that the other person is going to have coverage. If you do, you're making a huge insurance mistake.
Right, because it's not required in the state of Florida to carry bodily injury liability coverage. And so if you're going to pay money for your insurance, pay money to protect you and your family instead of just protecting everybody else from your safe driving. So that's my little lecture on uninsured motorist coverage. If you're just tuning in, you are listening to FLA Law on the radio. That's Bryan Caulfield. I am Matthew Noyce. We are two attorneys at the law firm of Pinellas Caulfield, Averill, and Noyce, the first personal injury law firm in Tampa Bay, going strong for 71 years now. As an appreciation for the community's trust in us, we present FLA Law on the radio every Tuesday, and then we post them on the podcast platforms thereafter. So you can't miss one episode of FLA Law on the radio. If you want to jump in, you're listening and say, hey, Bryan makes a good point or Matt makes a good point, or we make a bad point, jump in. Give us a call at 727-441-3000 or jump on our Facebook Live page at Bryan Caulfield, Averill, and Noyce Injury Lawyers, or even our YouTube channel, which is now live as well. And you can type in your questions or your comments right there, and we'll be happy to address those issues as well. Bryan, we're talking about if the e-bike user is injured. What happens if the e-bike user causes the crash? Is the auto insurance jumping in to protect the person that they may have injured? Let's say someone was walking on the trail and an e-bike ran into them.
Yeah, and that's
what does that pedestrian have?
Well, that's when things really become interesting, because you're going to take a look at what the coverages are that you might be able to access as a person that was run over by one of these e-bikes. Mm-hmm. And you're probably going to be faced with a bunch of denials. You'll ask for their auto insurance to cover it, and they'll be arguing, hey, it's a motorized vehicle and it's not on the policy, so we're not extending coverage for that. And then you'll see,
or it's a bicycle, and it's not insured on the auto policy.
It's not a motor vehicle, so it's not insured. And then you'll go over to their homeowners, and what will they argue? They'll argue just the opposite. They'll say, oh, yeah, that is a motor vehicle, and we have an exclusion. If it arises out of the maintenance, operation, or use of a motor vehicle, we don't cover it. There's plenty of litigation that's taken place over the years dealing with mopeds and golf carts. And, it's not uniform. It depends on the policy.
That's true.
And it depends on how many brake horsepower there might be on a golf cart, for example. Sometimes even depends on how many wheels they have.
Yeah.
Because there's some golf carts that have 3 wheels, and if the exclusion is for a 4-wheeled motorized vehicle, you say, well, hey,
I only got 3.
This is 3. So you didn't exclude it.
Well, I think that's why it's so important that if you do get injured, don't assume. Call us, call our firm, and get advice.
Yeah, a free consultation is what we offer to everybody.
Right. And if they wanted to do that, how would they do that if they're not listening to us on FLA Law on Tuesdays from 5 until 6?
Well, a number of ways. The easiest way is you pick up the phone and you call our office, and
talk to a live person.
Talk to a live person, not AI. And, we will get you in the same day to have a conversation about what your rights are if you've been injured as the result of someone else's negligence.
Right. And they can call us at 727-796-8282, or they can jump on our website as well and get some more information about it, and also set up a conference that way. What is our website? USA Law or voiceoftheinjured.com are That's
the two
right.
ways to reach us. Voiceoftheinjured.com is what we've been since 1955.
That's right. All right, we talked about the e-bike legislation that was vetoed, but I think there's another one that is very important too, that probably didn't get as much news and maybe not has impacted as many people, so it didn't get as much press, but it's something so important too. It's because DeSantis vetoed a compromise measure that would increase sovereign immunity limits in lawsuits against states and local governmental entity. Bryan, can you let our listeners know a little bit about what sovereign immunity is, and what the law was supposed to change, what damage caps it was supposed to change? Yeah,
sovereign immunity is a concept that kind of dates back to kind of old England. You're not allowed to sue the king.
That's right.
And
as we celebrate 250 years,
right.
So it brings us back
and
to
so
that.
Basically, any time that you're injured by someone that works for the state of Florida or any of its political subdivisions, and by that we mean, was it a town, was it a city, was it a county? Those are all sovereign defendants, and special laws apply to them. And it's probably one of the most unfair things that we have in our law, because you can go out and whether you're listening to us in Hillsborough County, Pasco County, or Pinellas County, or any particular city, whether it's Clearwater or St. Pete, you're out on the roadway and you see a huge dump truck that says City of St. Petersburg or City of Clearwater, Parks Department or whatever, tens of thousands of pounds. It's truly a true dump truck. It's driving down the road. But did you know that if the driver of that vehicle is negligent and hits and injures you or even kills you, that there is an incredibly low $200,000 cap as the most you can get? And it doesn't matter how many millions of damages they've caused to you.
Your medical bills, should you survive, could be in excess of $200,000.
Yeah, and so unfortunately that's a law that's been around in Florida, and it's had like no adjustment. I mean, this was years and years ago. They decided $200,000 would be fair compensation. Obviously, a lot has changed since then.
I think it started at 100, and then after years and years of being 100, they finally moved it up to 200.
Yep. And now, there was a common sense, kind of approach to upping that.
Yeah, it was a compromise.
It's like I thought we wanted people to pay for damages that they cause. Well, not when it comes to the sovereign defendants. And again, there was a bill that was worked out. It was a compromise bill. It would have raised things up to $350,000 per person, and it was vetoed. The governor decided that he thought it would incentivize unmeritorious lawsuits and increase financial burdens on local taxpayers. Well, you don't file an unmeritorious lawsuit because you don't win the unmeritorious.
That's right.
And so lawyers like myself, we have no, this is probably the oldest fake news, so to speak,
right?
That it would cause people to file frivolous lawsuits is really kind of the buzzwords that they're referring to, but they call it unmeritorious. Well, it simply makes no sense because a lawyer's not going to take the case unless it's a meritorious case.
Right. Because there's money and time that the lawyer has to spend.
And there's no reason why, these, kind of things should be out on the road. You could have two dump trucks next to each other. One is a privately owned construction company. If they hit and kill someone through their driver's negligence, then that case goes through the civil court system, and ultimately someone has a right to a jury trial to determine the damages. Doesn't mean they're going to get paid all the damages because there might be limited insurance coverage and money there, but it's totally different than when it's a sovereign defendant. And really, this is another example of the law not keeping up with the times.
Exactly.
$200,000 may have been good 20 years ago, but it's not so good now. It just isn't enough money. When you look at kind of the expense of medical care, things have gone up. Just natural inflation goes up, and there's no indexing whatsoever.
Well, you made a good point. I mean, if you compare, if let's say two different people get injured, the same exact injuries, the same because of two different dump trucks, but they did the same actions and has the same injuries, and both damages total $500,000. Let's just say. Well, if you're the unlucky one who got hit by the city dump truck, you only get $200,000. But if you are the one that got hit by the privately owned, then you get your damages. It just doesn't seem fair. And then when Governor DeSantis says that it's a burden on the local taxpayers, who's paying those medical bills if they can't be paid?
Right.
It's the taxpayers.
Exactly.
It shifts the responsibility from the at-fault party to us taxpayers.
Well, and it also, if the damages that can be awarded against the county are higher, what do you think that's going to do? It's going to incentivize the county to make sure they hire more responsible drivers and check on them throughout the operation of the vehicle and throughout the duration of their employment to make sure that they continue to be a good driver.
Right.
So it's kind of a hollow argument, but
I know.
Unfortunately, that's what's happened.
Yeah, several weeks ago, Lori Robinson and Jacqueline Bryant were on FLALAW talking about the St. Pete city garbage truck that ran over the woman in the alley that killed her. that would be capped at $200,000. And a death, you can't put a price on a life, but $200,000 just doesn't seem just.
Yeah, and it's not really even keeping that other states have done. It's just
Right.
it's far lower, and it doesn't make a lot of sense. And certainly, it's hard for you and I to explain that to someone when they come into our office and they've been hit by a county vehicle or even a police car,
Right.
for example.
Yeah.
And it does happen.
Yeah. So we talked about those two bills that passed the legislature but got vetoed by Governor DeSantis. And both of those, I think, are wrong decisions, but the decision's the decision. But there's also two things that I really wanted to talk about. We do have about 14 minutes left of the show. But one thing that is in effect right now is the change in the statute of limitations. In 2023, the law was changed to shorten the statute of limitations from 4 years to 2 years. Bryan, can you explain to our listeners, A, what a statute of limitation is, and more importantly, what impact that changing from 4 years to 2 years has on a person's right to bring a claim?
Sure. A statute of limitation is the amount of time you have to file a lawsuit against the defendant. And if you don't settle your case or actually file the lawsuit by that time, then your case is forever lost. It is time barred. So the statute of limitations for many, many years on a negligence case, meaning an auto accident, slip and fall, that type of case, has been 4 years. But unfortunately, in 2023, we had a change to our law to literally slash the time period you have to file a lawsuit in half. It sliced it from 4 years to 2 years. And that is going to have a lot of effect, some of which is what we call the law of unintended consequences. Because as you know, we've heard a hue and cry about how the court system is overcrowded. Obviously, COVID didn't help. Cases are behind. Judges are wanting and needing more, kind of facilities and help. You hear about that every year, that they're overloaded. Well, what did we just do? We just said now someone who's injured has to have their case settled or the lawsuit has to be filed within 2 years. Many times it takes longer than that to even figure out the full extent of your injuries.
Especially if you have to have surgery.
Yeah, so it forces people to have to enter the judicial system prematurely when they haven't even reached maximum medical improvement, when the case could be resolved by the parties. If you had the 4-year statute of limitations, I was resolving plenty of cases that might be after year 2 or even year 3. And the parties didn't have to access the judicial system.
Right.
They could actually resolve the case and not clog up the courts. Well, now, as you well know, you cut it to 2 years, we're having to file lawsuits on cases that we really don't want to file a lawsuit on yet.
Right.
But we have to, otherwise the case is forever lost. And furthermore, 2 years, sometimes it takes time to identify all the defendants in a case.
That's what I was going to talk about.
And by the time...
That's a risk.
Yeah, you figure out, okay, on this big whatever construction project, there was this other person that had a hand in, building this faulty balcony or something. And when you finally get it figured out, 2 years is already gone.
Right.
And so it's really a bad rule. I haven't yet heard a good reason for why it was done.
No, there just isn't a good reason. I had a case where there was an investigation. Somebody got hurt in an apartment complex because of a faulty rail, a staircase rail. Well, we brought the claim against the apartment complex. We tried to get it resolved. We couldn't get it resolved. The 2 years was coming up. We had to file the lawsuit, even though I think if we had another year, we could probably get it resolved. But then you hear that they're trying to blame a third party who came in to try to fix the staircase rail. Well, I had no knowledge of the third party. And with this 2-year statute of limitations, it just shuts down your ability to do the investigation, because that's 2 years to sue anybody and everybody who may be involved in, who may have caused the injuries.
Yeah, it's another bad change to our law that should be reversed.
Right. But one of the worst changes of the law is what I want to talk about, and that is the Modified Comparative Negligence law. Before
We go from bad to worse.
I know. So why don't we, Brian, if you would explain what the law was before it was changed, and then what it is now and the impact that has on many people who get hurt at the because of the fault of somebody else.
People have no idea until they come into their lawyer's office and start talking about something. And, I can tell them about the good old days when common sense prevailed and we had something known as comparative negligence. And Florida was what is known as a comparative negligence state. And basically what that means is that the law recognized that an accident can be more than one person's fault. And in fact, the person who's complaining about being hurt, that the accident could possibly be partly their fault. So for example, in a slip and fall case, you might have a case against a grocer and someone fell on a dark liquid substance on a white floor, and they would sue the grocer saying, hey, you were negligent for not cleaning that up before I fell in it. And the other side would say, well, we didn't know it was there, and even if we did, you were negligent for not keeping a proper lookout.
Yeah, open and obvious.
And so then the comparative fault was a concept where a jury was asked to take a 100% pie of fault and divide it up. What percentage of negligence, for example, was the grocer guilty of versus what percentage was the injured party? And so if they said the grocery store was 80% at fault and a $100,000 verdict, the person didn't get the full $100,000 verdict. They only got in accordance with the percentage of fault. So you'd take the total verdict of $100,000 and you'd multiply it by 80% because that's the fault of the grocer. And so that defendant grocer would have to pay $80,000.
$80,000.
Well,
and I don't have a problem with that. You want to hold people accountable and responsible for their negligence.
Makes
so if
total
it was
sense.
80, if it was 80, nothing more, but nothing less either.
Served us very, very well.
Right.
For many, many years here in Florida. I believe it's like over 50 years.
Yeah.
Well, the law got changed in 2023. Nobody knew it. You didn't hear any hue and cry, or you didn't hear, lots of shows.
People talking
about
it,
the good or the bad of it. But now Florida is no longer comparative negligence. Now Florida is what you might call a contributory negligence.
Yeah, modified comparative negligence.
That's what they call it, modified. But it's modified to hurt the injured victim.
100%.
Because the law now is if you are found to be more than 50% at fault for the accident you were involved in, you get nothing.
Zero.
Even though the other side was, for example, found to be 40% at fault, they no longer have to pay 40% of the damages. So a jury will be listening to the case. The jury can assign fault to the defendant, but one thing the jury doesn't know, if they assign more than 50%, the person doesn't just get their verdict reduced by their own percentage of fault like the old law.
Right.
If it goes over 50%, your recovery is wiped out.
Right. So if like in your scenario, if the jury awarded $100,000 and they found the plaintiff 51% at fault and the grocer 49%, you would think that they would get $49,000 to pay for their medical bills and the lost wages and pain and suffering. But that's not the case anymore.
Nope, they get nothing. And it's not just an example of cases that go to trial. What we're finding is that in premises liability cases, they're using this as like a complete defense. You call the insurance company,
yeah.
And the insurance company says, we're not paying anything because your client was more than 50% at fault, so we're offering nothing.
Right. And a lot of times there's auto accident cases where it's a he said, she said. Who had the green light?
Yeah.
Well, if the jury comes back at 50-50, because they can't decide who had the green light, the injured person gets zero. As I said, we want to hold people accountable for everything that they're responsible for. Nothing more, but nothing less. Well, I am okay with nothing more, but this gives them something less than
Yeah, you don't want to be found
accountable.
more than 50% at fault, or you're in deep trouble. And
No.
it's just, like I said, it's not just affecting things at the courthouse. It's affecting negotiations on cases because, you know, now you're hearing a new reason not to pay. And insurance
Right.
company says, yeah, we recognize our person was negligent, but we think yours was more than 50% at fault, so therefore you get nothing.
Yeah.
So it's been a huge change to the law,
No.
not a good change.
No, I know. Brian, we're about to wrap up this hour, but I did want to give you an opportunity. I didn't put this on our little note, so I'm going to throw a curveball at you. But I know you, like me, that we always have one or two points that we want to tell everybody. If we have an opportunity to tell somebody, we want to tell them. What are your 2 points that you usually want to tell people before they get involved in the accident?
I think the biggest thing, and you touched on it earlier, BUM. Uninsured motorist coverage is what I'm talking about. That's
Right.
what UM stands for. That is the most critical coverage you can buy for yourself, for your family. It clings to you and protects you wherever you go. If you go into someone else's car, it's like wearing a jacket of insurance protection that goes with you. If your kids are off in someone else's vehicle, it protects them. If you remember one thing about this show tonight, remember, insist on uninsured motorist coverage. If you don't have it, your agent's done you a disservice, and you do
100%.
not have full coverage.
100%. And I just glanced at iontampabay.com, whose creator is going to be on the show in a few weeks. But just today, here's three headlines. Largo man accused of 4th DUI after hit and runs, multiple crashes. You think he has liability coverage? Absolutely not. 19-year-old arrested after driving 113 miles an hour on Park Boulevard. Probably not the most insured. And third one, driver killed in high-speed crash on North Florida Avenue in Tampa. It's a fatality. Uninsured motorist coverage is so important, and not having it is crucial not only to you but also to your family. I mean, it protects you and your family, so it's so important.
Biggest insurance mistake you'll ever make. And most people don't even know they've done it because, as
Right.
you know, we meet with people and we
I
say,
have full coverage.
do you have uninsured motorist coverage? What do they say? Well, I have full coverage. I don't know. We
Right.
get their policy and they don't have it.
Right. Brian, thank you very much for jumping on the show tonight. I know you have a son's wedding to go to, so congratulations to your son as well.
Thank you very much. I'll
And-
be headed up to Maine.
Yes, and listeners, thank you for listening as well. As I always say, drive safely and watch out for those who don't. Take care.